evergreenlawnservice.com. Evergreen Lawn Service, offering organic-based lawn care services, now offers their mosquito control program to help reduce those nasty biting mosquitoes in your yard. Evergreen Lawn Service, making lawns beautiful since 1981. The Madeline Island Ferry, transporting passengers between Bayfield, Wisconsin and Madeline Island, while our customers enjoy the beauty of Lake Superior. More information and schedules online at madferry.com. Locally owned Lake Superior Garden Center, offering a wide selection of annuals, perennials, trees, and shrubs, plus beautiful garden ornaments and gifts on Jean Duluth Road in Duluth. More online at lakesuperiorgardencenter.com. Lawyers on the Line is brought to you by Falsani, Balmer, Peterson, Quinn, and Beyer. For nearly 40 years, answering the Northland's toughest legal questions, helping you understand where you stand. Falsani, Balmer, Peterson, Quinn, and Beyer.
Good evening. Welcome to Lawyers on the Line. I'm Jim Peterson with the firm of Falsani, Balmer, Peterson, Quinn, and Beyer, and I'm this evening's moderator. Tonight's topic is family law. Divorce is the single most common legal proceeding in the United States. Disputes in a divorce including division of assets, both property and money, as well as custody and visitation with children. I'm pleased to welcome tonight's panelists, three very good and experienced family law attorneys in Duluth. First, Terry Trogdon of the Gerlach, Beaumer, and Trogdon firm, Cheryl Prince of the Hanft Fride law firm, and Jessica Sterle of the law office of Jessica Sterle. Terry, Cheryl, and Jessica are ready to answer your questions about family law. The number to call if you have a question is 218-788-2844, and that should be appearing on your screen. If that's long distance for you, you can call our toll-free line at 1-877-307-8762. All right, well, welcome this evening. We'll start out with a couple of questions. I'd like to start out with a question about, do I really need a lawyer? Okay, here's the question. My wife and I have been talking about divorce. We don't have a lot to fight over. Do we really need a lawyer, Terry?
Well, you don't really need one, but if you have any idea of what it is to actually bring this thing to a conclusion, you ought to have one. In fact, I would think that both Jessica and Cheryl would agree with me that a lot of the cases that we get where we do a lot of work is where we are straightening out problems that people created for themselves by trying to avoid using a lawyer. So sometimes trying to save a little money will actually cost you a lot more.
Is there a criteria or some guidelines that would tell somebody, boy, I better get a lawyer, this is not a do-it-yourself? Cheryl?
I think that there's no reason that you can't try to fill out the forms. If you go to the court administrator's office, they have forms called the ICANN forms, or they're pro se forms. And they're very complicated in the sense that there's a lot of questions, a lot of pages. If you want to try to fill it out and do it yourself, you can save yourself money, but I strongly, strongly suggest that after you have completed them, even if you think you and your husband have an agreement, take it to a lawyer, spend an hour's worth of time having the lawyer look it over and go through them and come up with some, fact check it, make sure that it's correct, at least on a basic level. It's not going to be perfect, and the lawyer's not going to be able to do all of the issue spotting that true representation would include, but at least they can help make sure that it looks good and that there's no huge issues created by it.
In Minnesota, ethically, can you do like an a la carte representation where you're going to limit your representation to only one issue or one particular thing and not handle the whole case, Jessica?
There is this concept of unbundled services where you can do exactly what you're talking about. Some attorneys feel comfortable doing that, some don't. And tying my answer to what Terry and Cheryl said, if somebody has a gut feeling that they should talk to somebody, set up a consultation with an attorney. Spend an hour's worth of time getting advice, whether it's helping get the paperwork filled out, or to find out about unbundled services or any other issues regarding their legal matter, because I will firmly agree with Terry that we do clean up a lot of messes, unfortunately, when matters are done without attorneys, and we really would hate to see that happen.
Because there's a lot of things that are triggered in divorces. There's tax issues, there are support issues, there are real estate issues, there are estate planning issues that people aren't always aware of, and the decisions they make and the language they use in the documents unintentionally can create problems.
And there is no such thing as a simple divorce.
Okay, we have some questions coming in from callers already. Here's one. Back to you, Terry. Is there such a thing as common law marriage? This question comes from Wisconsin, but maybe you can address Minnesota also.
In Minnesota and Wisconsin, and I'm licensed in both states, so I can speak with a little authority, there is no common law. There are, I think, 7 or 8 states in which there is some notion of common law that's enforceable, but Minnesota and Wisconsin are not one of those.
Here's a math question for Cheryl.
Thank you.
If a man has 6 kids with 4 women, how does child support work out?
Very difficultly. The first person to the courthouse to get a child support order is going to be the person that starts the cascade in place. That first child support order is going to come into play when calculating child support for the next mother, and those 2 previous orders are going to come into play in calculating child support for the third parent. But it's all going to create a lot greater financial obligation than he'll enjoy.
Well, maybe a general question, because I think this has been changing since I last looked at family law in law school. How do you calculate child support in Minnesota?
Minnesota changed its child support laws in 2007, where we now follow what's called an income shares model. That is, we look at the income of mother and father, or parent A or parent B. And we can use a child support calculator on the Minnesota Department of Human Services webpage, and you can Google Minnesota Online Child Support Calculator. And you can find out how that gross monthly income that is used for both of those parents can be used to calculate child support. The child support world does have kind of its own language, and there is a glossary on that webpage to help determine what the terms mean and how to go ahead and calculate it. And that can be where also a consultation with an attorney could come in, where some child support calculations could be put together so the person can learn how to use that calculator.
One of the things that's used in calculating child support is what is called in Minnesota PICS, and that's the parental income available for child support. And if you think about what Cheryl said about the cascading effect, as you have more and more child support orders, the available income decreases, and so that impacts the successive child support orders.
Here's a question about grandparents' rights, and I'm guessing this comes up more and more frequently these days. What rights do grandparents have if they feel that the children, which I imagine means grandchildren, are not being cared for properly?
Well, that's grandparents do have rights, or they do have them. They can be enforced. If you have an intact family that is functioning with a mother and father and children, and they have just decided to cut the grandparents out for whatever reason, the grandparents are not going to have anything that's going to be enforceable in terms of rights. If you have a family situation where it is not intact and there are issues, the grandparents may be able to get some sort of court-ordered contact, but it has to be in the context of the grandparent not acting contrary to what the parents want. And it does require the filing of an action. Usually, it can be separate or it can be part of another family court action. So either way.
Here's a question about fault. I love this topic. If one spouse wants to divorce, but the other one says no, what do you do?
Unfortunately, there is very little, if anything, the spouse that doesn't want the divorce can do. In Minnesota, it's a no-fault state. If one party wants a divorce, that divorce is going to happen. It may not happen as quickly. The other spouse can put roadblocks in the way of getting to the end, but it will end.
Can the court order, some sort of reconciliation or counseling or something?
The courts cannot order reconciliation or counseling.
Here's a question from a viewer in Duluth. What can I do if my soon-to-be ex-spouse is following me or watching my house?
One option a person can look into is whether or not there are grounds for what's called an order for protection or harassment restraining order. An order for protection is basically where somebody's in fear for their safety or somebody has physically harmed somebody. Now, that's a standard that in Minnesota can be a little hard to meet at times because somebody is fearful is not necessarily enough. But another option is a harassment restraining order where somebody is not necessarily afraid for their safety, but somebody's behavior is really negatively affecting their life. Those can be two options. If somebody is concerned for their safety, they should call law enforcement and talk to an officer as well and report what they're being concerned about so that they can at least have law enforcement maybe get involved and maybe help as well.
Here, a question from Carlton regarding visitation. What happens if we can't come to an agreement on visitation? I imagine the court might have to get involved, but how does visitation work?
Well, visitation or parenting time is the time that the child spends with each parent, and under Minnesota law, as in most states, both parents have a right to spend time with their child. If there's an action out there, whether it's a divorce or a paternity action, then the court is kind of in the background on that one. What happens is that the court must consider the best interests of the children. There are certain factors that are used to determine that the court uses to support whatever decision it makes. Better, though, than having the court involved is if the parents can come to some sort of an agreement on what the parenting time should be, then they can have the court incorporate that into an order, and then it's enforceable. What we do know with parenting time or custody is that, or visitation, is that the children are going to do better if they have good access to their parents and if there's low conflict. Whether a child is 2 years old or 12 years old or 17, they all know that there is something going on. So if you can work it out without a judge getting involved in the decision-making part, that's the best thing.
Cheryl, here's a question. The caller's son has to pay child support, but can't work because of health reasons. Can the court force the son to pay child support even though he can't work?
Well, if he can't work, his option would be to make a motion in court to ask that his child support decrease or be eliminated. He needs to show that there's a reason that he can't work, and if the court finds that there's a change in circumstances, the court can eliminate child support. Unfortunately, if there is an order that he's supposed to pay child support, that order is going to stay in place until he makes his motion and until the court changes the order.
How long does that take? In Duluth, we do have a referee who does child support. How quickly can you get into court to get that modified?
It depends upon whether you're going to be working through the county system or whether you're trying to handle it on your own. Generally, if you are asking your child support worker to help you make a motion, they have a lot of things to do, and so it does tend to take a little longer to get it on the court's calendar. If you're going to make your own motion or you're going to hire an attorney, you can contact the court administrator. You need to fill out the forms that outline the facts that the court needs to understand about why the child support order should change. Once you've filled out those forms, you turn it into the court administrator's office. They can help you get a date, and the date is probably going to be within a month or so of the time that you turn the forms in. Now, those forms also have to be sent out to the other party and to the child support office, but it has to be at least 20 days from the time you turn the forms in until the time you're in court. But based on the court's calendar, it's probably going to be in a month or 6 weeks from the time until the time you get into court.
Jessica, here's a question. It's kind of fact specific, but generally a situation is the father does not have custody, is paying child support, has concerns that the mother is not able or not providing proper care for the children. How do you go about changing custody?
Well, in Minnesota, when a child is born outside of a marriage, mom has all the legal rights to the child. That father, he may feel like he's the father, but legally he's not recognized as one. It sounds as though he's paying child support, and I don't know if in the child support process the court found that he's the biological father and then legal father. But if he has not been found to be the legal father, he really needs to consider filing an action in court to become what's called adjudicated or found to be the father of that child. If the father has some concerns about the child's safety, it would be through that court process that the court would look at what's going on in mom's house as well as dad's house to see what is in the best interest of the child as to where that child should live, as well as how often that child sees both of the parents.
Well, what if, it doesn't really say here, the custody was awarded as part of a divorce or a dissolution? Is there a way to change the custody from what's already been awarded?
There is. A person could file what's called a motion for a change of custody. A motion is basically filing an action in court, telling the judge there's an issue or there's some issues that that person would like to have addressed. We are finding, though, in the court system that mediation has really become a way for mom and dad to try to work through their issues. I think we've been using mediation primarily for about 9 years. I think it's really in our legal DNA now. And a court would really want the parents to try to work out their issues regarding their child and even safety issues, hopefully through mediation to see if something can be resolved so that the court system wouldn't be the way where that parent would be dealing with how they see their child.
Well, I guess that's a new topic. What's a mediation?
A mediation. A mediation is where you have a neutral person who assesses the situation by talking to both parties, try to find their commonalities, and try to work out an arrangement where they come to an agreement. Mediation is confidential. Mediation should be non-confrontational. It should be in a safe environment. And one of the really good things about mediation is that people can agree to all sorts of things that a court can't order. So if you went into court and you asked the judge for, we need to have a parenting time order, and you have a situation where maybe mom's a firefighter and dad's a nurse and you have odd schedules, if the judge is just going to weigh in and try to divide some time, they may come up with any schedule. A family like that would need one that is able to be manipulated and has a lot of flexibility. You could incorporate a whole procedure on how to figure that out in a mediation, where in a court proceeding that would be very difficult and likely not occur.
Cheryl, excuse me, here's a question from Two Harbors. Am I responsible for debts my wife incurs after we separate but before we are legally divorced?
Yes and no. In family court, in a divorce court, debt is considered marital if it is incurred during the marriage, which means that it is incurred any time while you're living together or even after you've separated, as long as you're not divorced yet or the valuation date that the law would set, which is usually a pretrial date, hasn't occurred. So anything up until shortly before the divorce can be, quote, marital debt. It doesn't mean that it's going to be assigned to the other spouse. It's a possibility. However, being responsible, if you're asking, am I going to have to pay it because the creditor is forcing it and my spouse isn't paying it, that's a different question. Debt, the creditors can only have the spouse who has signed as an obligated party pay that debt. And if they haven't signed, unless there's some certain circumstances, you're not going to be, quote, responsible to the creditor for that debt.
I imagine if the creditor has both parties on the mortgage loan or whatever, they can go after whoever they want. They're not bound by the divorce, right?
Exactly. And that's a confusing aspect in many divorces. Parties will agree that husband is going to receive the house and he's going to be responsible for the mortgage, and wife is supposed to be off that, or is not supposed to have to pay it. 6 months, a year later, husband has stopped paying the mortgage. Wife is very upset because all of a sudden she has to pay it, and because she thought that just because it said in the divorce decree she didn't have to pay it, she doesn't have to pay it. Unfortunately, the divorce decree doesn't affect the bank's right to go after the parties who agreed to pay the debt. So that's one of those unintended consequences that occur when parties are trying to do things themselves. What usually you should do in those situations is you order the parties to refinance the debt into the individual's name so that you are no longer on it.
And I think that's an important piece of the representation, is assessing whether the person who is supposed to refinance is going to be able to do that based on the whole property division that occurs during a divorce situation. And it's not uncommon for a person who thinks that they can do that not to be able to do it. I think the one thing that we can tell couples when they're divorcing absolutely is that they will be in worse financial situation after the divorce than before, and not because of attorney's fees, but because of other expenses and not living in the same household.
And sometimes what we can do in divorces too is create agreements where there's mechanisms in place that if somebody can't refinance a debt, what should be done? And so there can be some creative alternatives done there.
Jessica, here's a question about maintenance. It says, if I make more money than my husband, will I have to pay him monthly maintenance?
Well, in Minnesota, the word maintenance really means spousal maintenance, or what we used to call alimony. The lawyer answer I would have to give to that question is it depends. And what I mean by that is we can't just look strictly at just the lone issue of spousal maintenance. There's the other debts and assets that are of the marriage. Would somebody who's the main breadwinner have to pay spousal maintenance? Well, if somebody's earning $60,000 a year in northeastern Minnesota, maybe. If somebody's making $40,000 in Minnesota, it depends. A court would have to really weigh what the parties' incomes are and their expenses post-divorce. Sometimes couples are divorcing and they have a high level of debt, and both of the parties' incomes are probably going to go toward trying to satisfy that debt and also try to pay for child support if there are children as well. So just because somebody earns more money is not necessarily an automatic trigger for spousal maintenance to be going into effect. It's just something that a person would want to consult an attorney about to talk about.
We're almost out of time, so we've got to do lightning round. If a father gives up parental rights, does he still have to pay child support?
The quick answer is no, but you can't just give them up. It's very difficult.
How do I get my ex-spouse to sign over deeds and titles that were supposed to be done as part of the divorce, but still not done 2 years later?
You need to bring him back to court and have a motion for contempt or motion to compel.
Who gets, I better read this whole thing, married 25 years, 2 children. When he retires, is ex-wife able to get a share of his Social Security benefits?
There's a 10-year trigger where a couple has to be married for a person to have some interest in somebody's Social Security benefits. That's really a detailed question for the Social Security Administration to really be able to determine. We attorneys really depend on the Social Security Administration for that, but that's something that should be really looked into.
I suppose it depends if they're still married and some other aspects also, but
actually, you can you can claim on your husband's spousal Social Security even if you are not married anymore.
If you were married for 10 years or more, and if you are not married to someone else, even if you've been married to other people in between. So it's pretty complicated, but probably, how's that?
How do you figure out who has to carry the health insurance for the children?
Boy, it's usually whoever can get the best coverage at the lowest cost.
My husband won't move out of the house. Can I force him to leave?
Not unless there is domestic abuse and you have the grounds for an order for protection.
We already did that one. We've been married 1 year. I paid my spouse's debts from before we were married, even his taxes. Can I get the money back now that we're divorcing?
Probably not. If you choose to use your money during the marriage to pay off previous debts, the courts generally consider it a wash.
How do we divide our retirement? I imagine like a 401k or something, now that we're divorcing. Does it depend on how long you were married?
Marital property in retirement account is the contributions or whatever was accrued during the period of marriage. If it's marital, it's divisible, no matter if it's 1 year's worth or 20 years worth.
Can I quit my job to lower my child support?
You can try, but it's probably not going to work. You're going to have the court understand why you left, and you're still going to have to pay as if you were working.
What if you don't have any money, though? Where does the money come from in that situation?
You can't get blood out of a turnip, but the child support arrears continue to accrue, and child support arrears are usually not dischargeable in a bankruptcy, so they will follow you for the rest of your natural life.
And there's interest, and there's sanctions such as incarceration.
And jail, yeah, exactly. They can take your driver's license, they can take other licenses away.
Hunting license, boat license.
The moral of the story is to not quit your job.
One more question. Legal separation, what's the effect of that in Minnesota?
Some people think when they just live apart, they're separated. They are, but a legal separation is a separate legal action where the couple still remains married, but they're dividing up the marital property. I don't really see it oftenly used, but it certainly is a mechanism. But if the parties are going to end up getting divorced, they're going to have to start all over and divide those things up, and then at that point the marriage would be over.
There's a different time requirement to be able to file legal separation. You can move into Minnesota and file legal separation the next day. To file divorce, you have to wait. So separation is kind of like a divorce without a divorce.
Okay. More like a temporary remedy, maybe? And
sometimes it's permanent, but you are still divorced. People will usually choose that as an option if there's some benefits involved or if there's some moral considerations where divorce is not in their vocabulary morally.
Well, this is a little different than we covered earlier. No, we're done. Okay. Sorry, that was going to be a really, really good question. That's all the time we have for tonight. Remember, you can watch our show again online at www.wdse.org or at www.duluthtriallawyers.com. Please join us again when next week we'll be talking about basic business law. Thank you very much to the panelists. That was really good. A lot of expertise. Thank you for watching. I'm Jim Peterson. Good night. What? You can do a read-through if you want to. What would you like to know about basic business law? Have your questions ready for an expert legal panel on the next Lawyers on the Line, Thursday night at 7:30 on PBS North. What would you like to know about basic business law? Have your questions ready for an expert legal panel on the next Lawyers on the Line, Thursday night at 7:30 on PBS North.